Court of Appeals Division 1 is now in session.
Good morning. Thank you. You may be seated. We're here this morning in Levy Company versus Maricopa County. Our case number is 1 CR2 Each side will have 20 minutes. Appellant will be responsible for reserving whatever time you wish for rebuttal. These proceedings are being audio and video recorded, so we would ask you to identify yourself and your client when you begin your argument. We have read the briefs. We've conferenced this matter earlier today, and we look forward to your argument. With that, appellant, counsel for appellant, you may proceed.
Good morning, Your Honors. I'm Stephen J. Lenahan, and I represent the plaintiff appellant taxpayer, Edward C. Levy Company. This case is an error correction case brought pursuant to the error correction statutes, specifically ARS Section 42-16-254. The legislature provided two statutory remedies to correct a classification error. The first is an appeal during the annual appeals process. That could be administratively or to court. The second, if you aren't aware of the error in time to appeal it, then the legislature provided the ability to file a notice of claim under the separate error correction statutes, and you're allowed to correct an error for the current year and go back up to 3 years. An error is defined by ARS Section 42-16-251 as it relates to classification as a legal conclusion applying the classification law to the use of the property.
So to use the error correction statute, are you saying the taxpayer can't know about the alleged error?
I'm saying the taxpayer, following Pima County versus State Board, can't know of the alleged error in time to appeal. But I'm also saying, just to be clear, is that the error isn't the fact that in this case the gravel pit was mined out. The error is that my client did not know of the correct classification.
What about, if I remember correctly, your client employed tax professionals to theoretically be looking at this, and they missed it? Is your client charged with their knowledge?
I think there's a real question as to whether a taxpayer or any principal is charged with knowledge that the agent didn't have. And in this case, clearly the tax consultant didn't have that knowledge, or he would have said, let's go ahead and appeal the classification. Of significance, though, is that in this case, the county has made the argument that the property is Class 1. We're asking that the property be Class 2. And when the county makes the argument that the property be Class 1, it must have a good faith belief to make that assertion. And that's under Rule 11A and Rule 8E2, I believe, of the Arizona Rules of Civil Procedure. So if the county has a good faith belief that the property is Class 1, then I don't think it's fair to charge the taxpayer with knowledge that the property is Class 2 back, so he could have appealed the classification of the property. It's one thing to charge a taxpayer with knowledge of something that is true. It's another thing to charge the taxpayer with knowledge of something that you don't believe is true, and that's what the county's trying to do here.
Well, you mentioned Pima County,
Yes.
the Pima County case. I have to confess I have doubts about that case. The statute upon which it based its knowledge requirement appears to apply to subsequent purchasers, not to all taxpayers. Would you care to comment?
Yes, I believe that the court relied upon ARS Section 16256 and 16255, which rely on which relate to new owners and relate to pending appeals.
Well, at least
our claim
256A, 16256A relates to new owners, and that seems to be where it got this doctrine.
Yeah, no, I think that's true. And the way I read the case is the court felt that this principle, which was in 16256, should apply to all the error correction statutes. And I think they did that in response to the county's argument that the taxpayer is abusing the system by waiting 3 years, and it can then either get a second bite at the apple or it can collect interest for 3 years. I think when interest rates were 10%, or when statutory rates were 10%, that might have been a good argument. I don't think we really have an abuse to correct right now.
So do you think the case was correctly decided on that point?
I think it may have been at the time. I don't think in this interest rate scenario that it would be.
I have to confess I'm nervous about statutory interpretation depending upon the economic realities of the time. Don't the statutes just say what they say?
Well, I think they do, and that would get us back to, I think your point is we get back to 16254, which doesn't have that requirement that the taxpayer not know of the error. But to me, whether we have the requirement or not, the provision that defines error is 42-16-251-3B defines classification errors. It specifically says classification errors pursuant to the classification statutes. So you've got to go look at classification statutes to get back to what an error is. It makes the term error a legal conclusion. So unless you charge the taxpayer with knowledge of the law, then you can't charge taxpayer with knowledge of the error. And I think the income tax analogy is a good one, is that, in all kinds of areas we charge taxpayers with knowledge of the law. But what we do in the income tax area, which is similar to the property tax area, is you file your tax return. If you find a mistake of law later, that maybe you treated some property as ordinary income property and it should have been capital gains, you have 4 years in Arizona to go amend your return. And you have that even though, arguably if the county came along, they'd say you should have known of the error. Well, in the income tax setting, you have the right to appeal regardless of whether you should have known of the error. Now, at the same time, let's suppose it went the other way. Let's suppose you had property that was ordinary income property and you claimed it as capital gains property. So as a result, you got a lower tax rate. I think I'm applying the federal law here, but you have a lower tax rate for capital gains. Well, there, you are charged with knowing of the error in the sense that you're going to have to pay the taxes, you're going to have to pay interest, and in all likelihood, you're going to have to pay penalties. So in that sense, yes, you're charged with knowledge of the error, but this is the first time I've seen knowledge of the law. This is the first time I've seen knowledge of the law used to disqualify someone from using a legislatively approved mechanism to challenge their taxes or classification in this case. The CNL is the only case that I'm aware of since Pima County versus State Board that really gets into the knowledge issue. And in that case, we had a taxpayer whose property was Class 1. They thought it should be Class 9. And Class 9 is land that's leased from the government where the improvements revert to the government upon termination of the lease, and where the land and improvements are used primarily for athletic, recreational, and certain other types of uses. Well, in this case, pretty clearly the taxpayer knew the land was leased from the government. He knew that pursuant to the lease, his improvements would revert at the end of the lease. He obviously knew what the use was, athletic or recreational or whatever, convention like in this case. But what he didn't know is that he should have been Class 9 and should have gotten favorable tax treatment. In that case, the government argued that the taxpayer should have known of the error in time to appeal and thus shouldn't be entitled to use the error correction statutes. And in that case, the court concluded that there was no evidence in the record that the taxpayer knew or should have known of the error, such that the taxpayer should be disqualified from resorting to the error correction statutes. Now, when you consider that the taxpayer knew of the underlying facts, the lease from the government, the reversion at the end of the lease, and the use of the property, the only way this court could have made that conclusion is if it did not charge the taxpayer with knowledge of the law. Taxpayer knew of the facts, obviously didn't know of the favorable tax law, and in that case, at the Court of Appeals, the court said that's okay, you're not disqualified in the manner that the county would seek to disqualify my client. That case, as you know, was overruled by the Court of Appeals, overruled by the Supreme Court, but the Supreme Court specifically said that the analysis relating to classification was correct and that CNL should be allowed to challenge the classification under the error correction statutes. The only other thing which I've already touched on is the county's inconsistent positions. And to me, it's very troubling that the county should be allowed to argue the property's Class 1 and at the same time tell the taxpayer you should have known it was Class 2. To me, that's just not logical. And I think it's confined by the rules of civil procedure as discussed earlier. Subject to your questions, that's all I have, and I'd like to reserve the rest of my time for rebuttal. Thank you.
May it please the court, counsel. My name is Neil Miller, and I represent the Maricopa County. And it's the county's position in this case that a taxpayer is barred from collecting tax refunds for alleged errors from previous tax years when the taxpayer had actual or constructive knowledge of the error during those tax years and failed to raise it in a timely filed tax appeal. I mean, that's it in a nutshell. That's what we're saying here. That's what our case
So
is
is it
all
all
about.
Pima County that you're relying on?
No, actually, there is other support in the statute with respect to the county's position. And I share your concern about the Pima County assessor case simply relying on the statute dealing with owners who purchase property in good faith. But one thing I want to point out is I think that what the court says, they cite that statute and they say...
Counsel, could we have you speak into the microphone
excuse
for the
me.
recording? Sorry, thank you.
Unfortunately, I'm sort of a little, I've got one leg here, which is not real good, and so I'm sort of leaning in one direction. I think what the court is saying in Pima County assessors, they're sort of deriving these principles from kind of a construction of the error construction statutes as a whole, and they cite that as an example. Quite frankly, they had some better examples, I think, that they could have cited to support that conclusion. And let me give you an example of what I'm referring to.
That would be helpful.
Under ARS Section 42-16255B, it indicates this article does not authorize an independent review of the overall valuation or legal classification of property that could have been appealed either administratively or judicially. So that's 42-16255B. Now let me point out that at the time Pima County Assessor was authored, that was 1999. The language or legal classification was not there at that time. The statute read, or that portion of the statute read, this article does not authorize an independent review of the overall valuation of property that could have been appealed administratively or judicially. But classification was added in 2009. So it makes it very clear here that what the legislature is saying, if you could have appealed the property administratively or judicially, then you can't come in and ask for an overall valuation or classification.
Well, what does could have mean? I mean, we're still, this whole gloss of knew or could have known or, you know, were you diligent enough, seems to be entirely a judicial creation. If the error existed or the disagreement could have existed at the time, then it could have been appealed. it just strikes me as rather untethered to any of the statutes to have this subjective state of mind test.
I think that what they mean was if, in fact, you were aware of the underlying facts and therefore you could have appealed it, then you had an obligation to do that.
Doesn't that essentially read out of existence the error correction statute?
Absolutely not. Absolutely not. There's any number of errors that a person might not be aware of. And that's one of the reasons why we have the error correction statutes. If you're not aware of an error in the valuation or classification or otherwise in your property, that's something that you can raise when it becomes known to you, and you can actually go back and correct or collect a tax refund for 3 years.
But when you're talking about valuation and classification, isn't the taxing authority always going to argue the taxpayer is in exclusive control of these facts and you're presumed to know them, and you're always going to be making that argument?
Well, I think again it's a fact-based sort of analysis, and it depends on the individual facts in the individual case. I mean, let's not forget, in this case, what happened is the property owner had a huge mined-out gravel pit. They essentially had mined it out since 2005. They were the ones that performed the study. They were the ones who knew that they couldn't mine it. They were getting notices from the assessor every single year telling them this was commercial property. It doesn't take a lot of legal sophistication if you're a property owner who's in the sand and gravel extraction business to say, gee, I've just got a notice. It says this is commercial property, but I've got this great big gravel pit, and I'm just not making any money off of it right now. So,
is there any basis to argue that the taxing authority has equal access to that information and should be filing under the correction statute itself?
Well, that's the argument I think that was made in this case by the taxpayer. The problem with that argument is, and this is a specific fact-based inquiry. We have this big flooded pit, but with these sand and gravel operators, they continue mining these pits even as they fill up with water. In this particular case, they were still using that property to support other mining activities on the property. They had a conveyor belt going down the side of the property. They were storing equipment on the property. So it would not have been apparent to the taxing authority, to the assessor's office, that this property wasn't commercially viable during the years in question. Certainly, however, it was something that the property owner had unique knowledge of. And they have the ability to file an appeal raising the issue of classification and or valuation on an annual basis. They have to do it either by December 15th, excuse me.
What if this were a church? They're operating a church that should be taxed differently than a retail establishment. The church just doesn't realize it's been miscategorized. They certainly know that they're operating a church. Does the error correction statute would not provide any relief within the 3-year period under that set of circumstances?
Again, it would depend on the facts, but if the church...
Facts are they know they're a church.
Right.
They're unfamiliar with the tax code.
Right. And what they're getting is, I'm assuming that they're getting a notice every year that says they're being taxed as a commercial piece of property. I would say that under that particular set of facts, the error correction statutes don't provide relief unless they raise the issue at the time that they have reason to raise it, when they get the notification saying that they're being taxed as a commercial operation rather than as a church.
And you base that on 16255B.
I do, and let me, if I can add.
You may.
If you go on to ARS Section 42, 16255B, it goes on to say, if a specific error of fact not previously known was not addressed in a prior appeal, an appeal may be brought pursuant to this section. So I suggest, and that language existed at the time that Pima County Assessor was authored.
And I'd like to go through that language with you carefully, because it says if a specific error of fact was not addressed in a prior appeal. Doesn't that presuppose the existence of a prior appeal?
Well, I mean, I think I don't think so. I think that what they're saying here is that if you didn't raise the issue in a prior appeal, then you can raise it later on, but it has to be a specific error of fact. And I mean, why would we set aside cases where the property owner does nothing? They sit on their hands for 3 years and decide at the end of that period of time, even though they're fully aware of the fact that they have grounds to file an error correction claim, they go ahead and they file it. And why would
The reason is that the tax court isn't a court of equity. The tax court applies the directives of the legislature, and the legislature apparently intended to expand taxpayer challenges when it enacted this statute. Going to the first sentence of the statute, which I understand has been modified recently, it says this article does not authorize an independent review. It doesn't say does not authorize a review. Now, independent of what, I guess, is the question. And it seems to me that the only logical answer is independent of an appeal that has been filed. In other words, you don't get 2 bites at the apple, but you can choose which part of the apple you want to bite.
Well, I think that's exactly right.
Okay.
And I think that a taxpayer is either they file their appeal, which they have to do on an annual basis, they have to do it by December 15th of the tax year, or they are barred from raising the issue.
Well, no, they are barred from raising the issue in an appeal, but it doesn't say that they're barred from raising it under this article. It simply says that the article doesn't authorize an independent review. Why the use of the word independent?
You know, that is a good question, and the only thing that I can say about that is that I think they're talking about we don't want the courts to have to go back and continue looking at these issues
Again and again,
when in fact they could have done so at the time that the issue was apparent to the taxpayer and they could have raised it.
If that's the intent, then isn't that different from your argument? Because your argument is we don't want the courts going back and doing this when they could have done it the first time. And I think what you just said is consistent with the way I'm reading this, which is we don't want the courts to go back and review this when you did do it the first time.
I don't think that's what I said. And I think that what they are saying here is you need to raise the issue when you're aware of it, or if you want to use error correction relief, or raise it during the appellate procedure, which you can always raise during the valuation year on an annual basis.
Seems such a simple thing to say. If that's what the legislature meant, why not just say it?
Well, why do they have the additional language in here talking about a specific error of fact not being previously known, not being addressed in a prior appeal? It would strike.
Doesn't that simply mean that if there was a prior appeal and this specific error of fact wasn't addressed,
right,
you can address it now if you didn't know it? But if there was no prior appeal, then why would that third sentence have any application at all?
Well, my question is, if in fact there was no prior appeal, why is it that we are limiting people who make the effort to file their notice of appeal and saying you can't come back later on and raise an error correction claim if you didn't know about it at the time and raised it in your appeal, yet the taxpayer who does nothing knows about the basis for their error correction claim?
We're just saying there's been a ruling on that issue already. We're not going to revisit something that's already been decided. That seems different than the taxpayer was unaware, whether it's of the facts or of the law, and no court has ever passed on this previously. Seems to me the way that seems to be a logical reading of the statute.
Well, and then you do have the language in Pima County Assessor that does read in this limiting error correction relief to errors that people either reasonably should have known about, had actual or constructive knowledge of. And let me just point out one other thing, too. When you look at this issue within the greater context of the property tax statutes and the error correction statutes, what is happening here, what essentially a reading of this to allow this type of error correction relief is saying to a taxpayer, okay, you go in and the person who files their classification claim alleging an error on an annual basis, that person is if they don't file it by the time that they're supposed to file it, which is December 15th of the tax year, they're barred. But if you just wait for 3 years, you can file an error correction claim for the exact same reason and go back and collect taxes for the 3 years prior to that. And I suggest to you that that's just an inconsistency in the statutes. And it doesn't make a whole lot of sense to have these two separate tracks. One, error correction relief, you can file it whenever you want. and you get to go back 3 years.
It's not complete overlap between the two statutes, is it?
There certainly is not. And what would make these statutes consistent would be a finding or would be a requirement that a taxpayer is simply required to raise the error correction claim if they want to claim it pursuant to the error correction statutes at the time that they knew or they reasonably should have known about the error.
Well, that sounds like an argument for the legislature as opposed to this court. I mean, you're asking us to interpret and harmonize these statutes by inserting language in there that seems to me is best reserved for the legislature. If there's inconsistencies here, I mean, our job is to apply the statutes as they're written, and the requirement that you're suggesting is not in this language, in these statutes.
Again, I would suggest that the language is there. The statutes do talk about issues of limiting these error correction relief.
Should have known appears that nothing even closely related to that concept appears in any statute that applies to this situation.
Well,
It's true that Pima County sort of teased it out of an inapplicable statute, but how are we to perpetuate a rule that the legislature didn't write?
again, I think that there's additional statutory authority within the statute. And I think, again, as I said earlier, I think it makes sense within the broader scheme of the property tax statutes. Because here's what we have now. We have an owner who's now who is allowed potentially to file an error correction claim, sit on their hands for whatever reason. Maybe they did it for strategic reasons. I don't know.
What strategic reason would there be? I mean,
I don't know. Maybe they just made a bad legal decision.
But it seems more logical to me that it's simply that the property owner is not as familiar with the legal ramifications of the use of the property. I don't think there's any question the property owner is in a better position to know how the property is being used, but that doesn't jump out at me that the property owner should necessarily know what the categorization is in our tax code. And if they figure that out later, if it's a favorable categorization, they have every incentive to do it earlier. So I'm not understanding how there would be possibly any incentive for them to just sit on their hands. The sooner they do it, the quicker they get a refund.
Again, I don't know why they would decide to do that. Certainly, they're not going to
That
be.
the legislature had just made a choice that if they figure this error out, and it's just within a 3-year period,
Right.
If they figure it out, then we're going to give them relief. If they don't figure it out within that 3-year period, they're out of luck.
Well, and they should get relief, but they should get the relief going forward. I mean, we shouldn't put the taxing authorities in a position of having to refund taxes for 3 years for something that a taxpayer had absolute knowledge of and could have
We should
raised.
put the taxpayers in the position of paying taxes that were not legally imposed? Is that preferable?
Well, in this particular case, the assessor never has taken the position that there was an error here. So I mean, that's part of the problem too.
Assessor hasn't, but
That's
the
correct.
question is, what is the correct answer? And if you're saying that we should assume that the legislature's policy was not to burden the assessors with refunds rather than not to burden the taxpayers with unlawful taxes, I suggest that you may not have the pulse of the legislature. I don't think that there is a legislator out there who would say we just want to stick taxpayers with whatever we can get. The taxes are supposed to be those defined by the law.
Except that if these issues are raised in a timely manner, they can be litigated in a timely manner, and we can do. And I mean, again, this particular issue could have been resolved back in 2008. Why are we waiting now to try to deal with this issue?
I'm trying to understand a scenario under the county's theory that would allow a taxpayer to bring a claim under the error correction statute that doesn't involve some internal calculation error by the county that the taxpayer wouldn't reasonably have access to within the year. I mean, really, what you're saying is any fact that is knowable to the taxpayer about their property that would affect valuation or classification has to be brought as a matter of law on an annual basis. You can never use the error correction statute to bring that claim within 3 years.
You can use the error correction statutes, but what I'm arguing is you cannot go back and collect back taxes, that we have to, I'm arguing that we're limiting going back 3 years, because it doesn't make a lot of sense if the taxpayer had the option, and in this particular case, it's very clear. They could clearly have filed an error correction claim, or they could have filed an appeal back in 2008. They had legal representation. This is hardly an unsophisticated
This is
taxpayer.
prospective. They can do that when their next notice comes.
They can do it the next year. I mean, that's...
Reads out of existence the error correction statute.
Well, no, because if you look at the error correction statutes, there's a whole lot of other things that are included in it. And a lot of those things just might not be apparent. And I can sit here and try to conjure up hypotheticals, but you're right. I mean, what I think of is the hidden errors. A taxpayer not realizing that they have been, let's say, assessed and taxed on the basis of something that they're not getting notice for. And again, these would be fact-specific kinds of inquiries. This case, nothing could be clearer in this case. This case presents a very clear picture of someone who...
In the case of it's a church was being taxed as a business, and the church just didn't figure it out, even though they obviously know they're a church. The legislature didn't have them in mind with the error correction statute. They're okay with the church just paying taxes that really should never have been paid.
Again, I think if you look at the error correction statutes, there's an indication that the legislature wanted to limit this ability to go back and collect back taxes. I mean, let's not forget, they get interest for that. And it affects the taxing authority in the terms of their ability to plan for future. And again, why would you have a taxable scheme that allows someone to file their error correction, or excuse me, a classification claim on an annual basis, and they're barred if they don't do it by December 15th, let's say?
There are two different procedures. And the first, the appeal procedure is more expeditious. There is an incentive to pursue that. The taxpayer loses that expeditious procedure if they don't proceed expeditiously. They have to use a arguably more cumbersome procedure. So there is a difference, isn't there?
I'm not so sure it's a more cumbersome procedure. All they have to do is file an appeal with the tax court, just like you would with your annual appeal. And what they do is they simply claim it's an error correction, and they demand a tax refund for 3 years. You know, in this particular case, the notice of error correction claim was filed in late December of 2011. So for them to be able to get relief in 2012, they would have had to have filed their appeal by December 15th. Of 2011 to get relief for 2012. To get relief for 2011, they would have had to have filed their appeal by December 15th of 2010. They didn't do any of that. They just came in at the very end of December and said, okay, here's our error correction claim. Now give us a tax refund for the 2011 as well as the preceding 3 years. When the entire time they clearly knew about the basis for this. And again, we're not talking about something that would have been difficult for them to figure out. And we're not talking about an unsophisticated taxpayer. They had legal representation.
Thank you.
Your Honors, please bear with me while I tell you a number of things that I suspect you already know. First, as set forth in the briefs, my client didn't sit on its hands. There's a sworn affidavit that it didn't discover the error until late 2011. As you know, you're allowed to go back 3 years to correct a property tax error. The undisputed evidence is that this pit was mined out in 2005. Had my client known of the error and been able to file in 2010, it would have picked up an entire extra year, so another year of tax refunds. There certainly was no reason to sit on its hands, and it didn't. The effective repeal argument that I've made, applies really to both of the county's arguments. Their one argument is under the Pima County assessor case, that if you knew or should have known of the error, you can't use the error correction statutes. The other is under 4216-255B, the independent review argument. If you can't have an independent review of an error that could have been appealed. If the county were to prevail on either of those arguments, it would effectively write out of the statutes the portion of the error correction statutes relating to classification errors. And as the county indicates, there are many errors a taxpayer might bring, but classification errors is one of 5 listed categories of errors in the error definition, and you wouldn't have any if you ruled the way the county asked you to rule. The error of fact, excuse me. The error of fact was in ARS 4216-255B was incorrectly addressed by the county. It quoted the statute as specific errors of fact not previously known may be brought pursuant to, and then it paraphrased the error correction statutes. What the actual statute said is that it may be brought pursuant to this section, section 4216-255. Our case was brought pursuant to ARS 4216-254, so by its terms at least, that provision would not apply. Also, that's the only place in the error correction statutes that discusses error of fact as opposed to error as defined in 4216-251. And that language was added to the statutes in 1998. That was during the time that Pima County Assessor was working its way through the courts. Pima County Assessor, as you know, was a 1999 Court of Appeals decision. And in that case, in that legislation in 1998, the Senate indicated that this provision, the sentence that reads, if a specific error of fact not previously known was not addressed in a prior appeal, an appeal may be brought pursuant to this section. And what the Senate fact sheet says is authorizes property tax appeals to be brought for previously unknown errors of fact that have not been addressed in a prior appeal. And so the legislature, at least at that time, was not trying to impose a new restriction on the taxpayer. It was trying to open things up because it was aware, presumably, of the Pima County Assessor case where the county was trying to prevent a taxpayer from correcting an error that arguably the taxpayer should have known of before. The Pima County Assessor, which seems to be the lead case here, or that was CNL, not only discussed the prohibition of using the error statutes if you knew or should have known of the error, but it also addressed a res judicata argument made by the county in that case. And what the court said is that, well, county, you're correct. The taxpayer did bring a valuation appeal as to this same exact tax year, but it didn't bring a classification appeal. And while we agree that the elements of res judicata are generally met, we don't believe the legislature intended to apply res judicata to the error correction statutes. And the reason we don't is because it would effectively merge the error correction statutes into the annual appeal statutes. And that's the same as my effective repeal argument, is instead of having 2 different systems, you end up with one, and that's the annual appeal statutes, and that's of course what the county is arguing for, is that we have one system even though the legislature provided for 2. The idea that the taxpayer knew the property was Class 1 because it received notice cards, well, I suspect it probably did know the property was Class 1 because it received notice cards. I think CNL, when it received notice cards, probably knew its property was Class 1 also. Just in both cases, as we've mentioned before, the taxpayer did not know that it was entitled to more advantageous tax treatment, Class 9 in CNL, Class 2 in our situation. And both of those claims were to correct that mistake of law, so to speak. You've mentioned some cases, Lyons versus Pima County. There's also Telco Federal Credit Union, E.C. Garcia, Abrams Airborne. All of those are error cases involving a mistake of law. In Lyons, it was the church case. In Telco Federal Credit Union, it was a credit union where pretty clearly they knew they were a credit union. They didn't know they were entitled to, at that time it was Class 4. Today I believe it would be Class 2. E.C. Garcia, they knew they were using the property for agricultural purposes. They didn't know they were entitled to special treatment or special valuation under the agricultural valuation statutes. Abrams Airborne, the taxpayer, it's a personal property case, the taxpayer made a mistake and categorized some of its personal property in the wrong category that would result in a higher tax burden. It was allowed to correct that error even though it was the taxpayer's own error. And again, those were all mistake of law errors where taxpayers in the past have been allowed to correct their errors. That's really all I have unless you have any questions for me. Thank you very much.
Thank you. Thank you both for your arguments. We'll take this matter under advisement and issue a decision in due course. And we'll adjourn for a brief recess.